my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times we will get calls from clients and they'll say, I went through a divorce, I didn't hire you guys, probably should have. I'm very unhappy with the result of my case. What can I do? Well, I have to tell you that when somebody is unhappy with a decision of the court, the knee-jerk reaction of lawyers is to tell them, file an appeal. Take appeal before the Michigan Court of Appeals. That's what it's there for. I have to tell you, though, you have to understand what's involved in that. Number one, the Court of Appeals is only going to look at the case and determine whether or not there's some kind of error that the judge made that is not a harmless mistake, but rather a significant error, and as a result of that, there was a wrong decision. So if the court feels the court made a mistake, but the Court of Appeals says, you know what, we wouldn't have done it that way, we would have done it differently, but nonetheless it's within the court's discretion, or we feel that it ultimately didn't make a mistake even though the court let this evidence in, or if that's what the court feels like, then the appeal will fall flat. Remember, you can't just appeal the case because you don't like the result. You have to appeal the case for reasons that have to do with those reasons that are acceptable to the Court of Appeals. You may go to your lawyer and say, well, I'm very upset. I want to appeal because I got a bad judgment. Well, that's not exactly the beginning and the end of the analysis. What you're going to have to do is, when you retain an attorney to do an appeal, the first thing he or she is going to do is look to see, is there a basis for it? Just because a client says there's a basis for it doesn't make it so. On the other hand, if a client says there's nothing I can do about it, that doesn't make it so either. There might be something you can do. Maybe an appeal, either for reconsideration by the same judge or appeal to a higher court, might work. But generally speaking, the Court of Appeals is going to look at the case, at the transcript of the hearing, and say, did the judge let in evidence he should not have considered? Did he fail to let evidence he should have considered? Did he make that mistake? And did that change the ultimate decision? If the court feels yeah, then they'll reverse and they'll remand for further proceedings. Understand, though, while all of this is going on, it is not likely that the court's going to stop the matter. It's not going to stay the matter. So if it's a custody decision and mom got the custody while your appeal is going on for a year and a half, the kid is still with mom. It's not like the kid is held in abeyance somewhere, or the kid is with you until the Court of Appeals makes its decision. Same with assets. Unless there's a stay, the court may make a decision one way or another, but you are going to be subject to that decision. Collection proceedings, seizure, all these other things that occur when somebody owes somebody money, those are still going to happen unless there's a stay. So these are the pros and cons of filing an appeal. Now, if you have any questions about your case, of course, reach out and we'll be glad to help you out.